My last video series touched on a personal injury or accident claim, and I want to explain to you the term litigation or filing a lawsuit. People have heard the term litigation, you've probably seen it on TV or heard other attorneys talk about it, but that actually means the mechanics of filing a lawsuit and what you go through prior to getting in front of a jury. And in Arizona, if you file a lawsuit against someone for their negligent acts and for your damages, as we explained before, two parts of your claim, then what you do is you file a complaint in one of the superior courts, depending on what county you're in, have it served on the defendant or defendants, and they have to file an answer. Once the answer is filed, then you really go to work. There's a series of what's called discovery. The defendants are entitled to ask you a series of questions in writing, or ask you to produce your, let's say, your medical bills, your medical records, and in turn, you can ask the defendant certain things. Had they been drinking that night? Have they been convicted of any felonies? It's pretty broad, the kind of questions that can go back and forth. And just so you know, when you file a lawsuit against somebody, you are opening up your life to them and to really just about any question imaginable. Now, just because they ask a question prior to a trial doesn't mean that they can ask it in front of a jury. It has to be relevant in front of a jury. So you go through this discovery process that, believe it or not, can take a couple of years. On top of that, the defendants can ask that your deposition be scheduled and set. And that typically is in a conference room with a court reporter, you know, the person that sits there and they're typing on a little funny machine. Nowadays, it's a little higher tech. It can be higher tech, and it's a video deposition. And the other attorney for the defendants can ask you a series of questions. And again, it's pretty broad. And very few objections are made by me of my clients in a deposition because it is so broad. Again, it's not like a trial. So after all this discovery is done, then you let the court know, hey, you're ready, we want a trial date. And again, it takes a couple, 3 years to get in front of a jury. Once you are at that point, the first step is picking a jury. And you do that, it's sort of a misnomer, the term picking a jury. You really exclude who you don't want for maybe cause, meaning that they've got some kind of a bias, or just because you don't like them. And you have a certain number of strikes, and so does the defendant, and who you have left, possibly 10 people, are the ones that sit there. You might have the 10 best that you would have picked had you been able to pick them, or 10 people that you just couldn't get rid of for one reason or another. And they will sit and they will listen. You're the plaintiff. You're the person suing somebody. The obligation and the burden is on you to prove your case. Now, in a criminal matter, it's guilt beyond a reasonable doubt. In other words, the state or the government has to have a ton of evidence about difference like between here and the scales of justice. In a personal injury claim, it's a preponderance of the evidence. It's like this, just slightly. In other words, 51% versus 49%. So you need to convince the jury with just a little bit more evidence than the defendant can essentially rebut or block, if you will, or defend against, and convince the jury that, hey, this guy blew through a red light, and he caused you to break your leg, or break your arm, or have permanent eye damage. And the jury gets a series of instructions from the judge that the attorneys have agreed to. And what happens then is they take the instructions after all the evidence has been presented, and I present my case. The defendant gets to cross-examine all of my witnesses, which is pretty broad, and then I get to redirect my testimony, so I get the last word. And then the defendant will bring on their people, maybe their client, to say I didn't run a red light, or their expert to say there's no way you could have had a broken leg from this accident, you must have had it before, things like that. An incredible amount of money is spent going to trial. If you can avoid a trial, you want to, because nothing's guaranteed in life, and you don't know what a jury will do. And on any given day with any number of people, you don't know what a jury's going to do. No matter how good your case is or how bad your case is, you never know. It's a roll of the dice. Roughly 98% of any personal injury claim settles before trial. It may settle the day before the trial, but they settle. Only about 2% of cases end up going before a jury with a jury verdict.